10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello. Hello, my friends, and thank you so much for coming to spend part of your Monday, February 26th, 2024 with me. I think a lot of us were expecting a lot more from the Karen Read hearing today in Norfolk Superior Court in Dedham, Massachusetts, but despite the fact that a lot of you may have thought it was short and boring and not as explosive as you might have liked based on David Yannetti's tweet yesterday, we did learn a lot. Oh, Sammy Joe, I am going to make it make sense. I'm here. I'm here for you. I'm here to make it make sense. I'm not feeling the greatest today, so I'm a little congested, so excuse my voice. The hearing today was all of about 15 minutes long. We're going to watch it together. We're going to take a look at some court TV coverage before and after the hearing. See what they had to say, because one of their talking heads had some very interesting things to say, I thought. And we're going to take a look at David Yannetti's tweet from yesterday. So hello, everyone. That's my Seinfeld reference of the day. David Yannetti, who, as you know, is the original counsel and now co-counsel for Karen Read in her case, her secondary murder case for the death of John O'Keefe, police officer John O'Keefe, tweeted yesterday. He rarely tweets, so it was interesting to see his tweet. A lot of people were making a big deal about it. And his tweet was a quote from Teddy Roosevelt. Teddy Roosevelt's speech from the Sorbonne, Paris, in April of 1910. And I will read that to you. He quoted, "It is not the critic who counts, not the man who points out how the strong man stumbles or where the doer of deeds could have done better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs and comes up short again and again, because there is no effort without error or shortcoming, but who knows the great enthusiasms, the great devotions, who spends himself in a worthy cause, who at the best knows, in the end, the triumph of high achievement, and who is at the worst, if he fails, at least he fails while daring greatly, so that his place shall never be without those cold and timid souls who knew neither victory nor defeat." And then, at the end of his tweet, he added 3 sentences. "We are in the arena. The triumph of high achievement is coming. Justice is coming." And as of just a little while ago, it has over 200,000 views on Twitter. I'm going to call it Twitter forever because I'm just old school like that. So I think based on his tweet yesterday, we thought something was going to happen today. Either maybe the charges were going to be dismissed or some explosive information was going to come out at this hearing. But if you know Judge Cannoni, you know that she runs a very tight ship. She doesn't let people really, really speak. She kind of cuts them off and tries to get her agenda done quickly. And as such, you know that because you've watched her, and we've watched her hearings together before as well. So what we did learn today is that the feds have dropped 3,074 pages of what Alla Jackson, our smooth as butter defense attorney for Karen Read, who is from LA, who has defended many famous people, including Kevin Spacey. He calls it brand new and exculpatory evidence. In the case of Karen Read, it is 1.3 gigabytes of data, and it is voluminous. So let's take a look together, shall we, at the hearing. And as we go through, I'm going to stop and give you commentary and talk about my thoughts. And please let me know your thoughts as well. Just let me know that you can hear it. Yeah, lot. The audio was markedly better today in court. Some days it's really, really, really bad and low, and you can't even hear it. Yes, Darcy, that's a lot of pages. Yes, Mr. Cheesecake, they flew in for a 15-minute hearing. They had asked for an adjournment of this hearing last week, but it was never granted or denied, so everyone had to show up today. This was originally scheduled to be the hearing on the motion to dismiss the indictments that we went over the other day, but we actually couldn't go over the entire motion because the defense motion is still impounded. We did look at the Commonwealth's opposition to that motion. It's interesting that that motion is still impounded or sealed, as we would say here in New York, under seal. There's a little chit chat. Hello, I just want to thank all of my amazing moderators. Thank you, Peter Pranzo. And to all of my amazing moderators who keep the chat classy. We like to keep it classy here. So you are welcome to chat, but we don't tolerate foul language, personal attacks. We like to keep it classy. Scott is another one of my amazing moderators who was on my last Members Only Live, came on and did a whole show with me. That was a lot of fun. Many of my moderators are retired law enforcement, so they do protect me, and we're not going to tolerate the trash talk. And look who's here. Glare is here. Hi, Will. Team Brittany is another amazing moderator. Please don't do the name calling thing and keep the chat respectful, please. Thank you all for being here. Thank you. The sound always gets better when Jackson starts to speak because he knows how to use a microphone. Crazy, right? Imagine that. Rich says 3,100 documents is about 2 bankers' boxes. Cannot confirm nor deny that. I just looked, Mr. Cheesecake. The defense motion is still impounded. I literally just looked on the docket. The motion to dismiss the indictments is impounded. The other motion is not. The motion to disqualify. We did go over that on my last stream. I think that was 2 nights ago. The attorneys are also in possession of the Verizon records. I believe those are the records of Jen McCabe, because those were logged in, I think, on Friday. I agree with you, Cami, because Cami says, how did the Commonwealth read 3,000 pages already? I find that hard to believe. So do I. But that's what they're going to say. There's our friend Jim, court clerk. Ribbon butts is a coping skill mechanism. A lot of people smoke a lot when they are nervous or have anxiety. Yeah, Hammer says, what is your favorite Dave Matthews song? I have so many, but I love Gray Street. I think that's one of my top picks. Stay or Leave is another one. Crash. Warehouse. I love so many songs. Anybody else wants to put their favorite Dave Matthews song in the chat? Happy to hear it. Thank you, Truth Seeker, for saying this is the classiest channel. I try. I like to give people an alternative. Some people like to watch coverage with their 95-year-old mothers and they feel that, or their children, they feel like at least this is a safe place where they can do that, so that I'm not dropping F-bombs. Scott McGinnis, I have to switch gears from protester to cupcake. Oh, were you protesting today? Or protesting? Peacefully protesting? Were you outside the courthouse?
All right.
I'll be quiet.
If you see to go to town section, turn up your cell phone.
Afternoon. We are on the record on Commonwealth vs. Cameron Reed on docket 22 CR 117. Beginning with the prosecution, can we have the parties introduce themselves?
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon, Mr. Jackson.
Good afternoon, Your Honor. Elizabeth Little,
Good
also
afternoon.
on behalf of Ms. Reed.
Good afternoon, Ms. Little.
Good afternoon, Your Honor. David Yannetti for Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Reed. Okay. Oh, all right. So here comes Mr. Lally. Were you expecting him, Ms. McLaughlin?
Yes, Your Honor.
All right. I'm sorry. I would not have started.
She was probably freaking out that Lally wasn't there yet. So Lally walked in late, and apparently the judge was surprised to see him too. I know that the audio, I'm going to try and speak softly and carry a big stick. Well, there's another quote for you. Because I know the audio is low and you probably have to turn up your TV, and I don't want to blast you out.
All right. So, Mr. Lally, if you just say your name for FTR to
Yes,
get
sure.
out.
I'm Lally for the Commonwealth. Good
All
afternoon.
right. Good afternoon, Mr. Lally. Okay. So when we were all last in court on February 15th, there was obviously Mr. Lally, why don't you have a seat? A joint motion to continue the motion to dismiss and the motion for sanctions and disqualification, and have those heard on March 12th. So at the time, as you all remember, I said it was premature. So now we are in receipt of your motion to continue because of recent developments. So I'm also mindful, I did just this morning receive a letter from the Deputy U.S. Attorney.
Okay, so the Deputy U.S. Attorney is writing to the judge. It's a big deal, my friends. That is a big deal.
And she made it clear that the parties can make oral references to the contents and the materials and proceedings in this courtroom. But she also cautions that only is necessary to further the proceedings. So in light of that caution, I obviously have not seen and have no idea what these materials are. In light of that caution, what I'd like to do is set some dates. I do agree that we can hear that motion to dismiss and motion for sanctions and disqualification. So I'd like the parties to, it says you received the information from the U.S. Attorney's Office on February 21st. And I know you outline in your motion that it's very voluminous.
That's correct.
All right.
The evening of the 21st, we basically have had access to it starting on the 22nd until today.
Okay, so that's why I'm going to give you until March 6th to file any supplemental memo or motion on those two.
Okay, that's not a lot of time. That is not a lot of time at all. So they just came into possession of these materials. Today is Monday, February 26th. They came into possession of these materials on the 21st, the evening of the 21st, which was last Wednesday. And she's giving them until March 6th. That's 9 days. 9 days. That is a ridiculously small amount of time to digest, brief, have experts look at all of this material, which Alan Jackson is going to tell you how much material it is, but she's not really going to let him talk much.
2 point on the motion to dismiss and motion for sanctions. So the defense has until March 6th to file any supplemental motions and memos on those two. The DA has until March 11th to respond. And on March 12th, we'll have a hearing on those motions.
Your Honor, if I may be heard.
So they have literally less than 24 hours to digest the prosecution's response before they have to come in on the 12th and argue the motion. It's an enormous motion. This is the motion to dismiss the indictments based on prosecutorial misconduct and bias that we went over the other night. I mean, that's a really, really tight timeline, and I would suggest to you that it's unfair. But hey, that's just my opinion. But if I was Alan Jackson and I was her defense team, I'd be saying, are you crazy? Like, there's no way.
I have more of a scheduling order, and then I'll hear you.
I
Okay?
just want to be here on the scheduling before we move off that topic, so thank you.
Yep. No, this is all the dates that we're moving. You move to continue, and these are the dates we're having. Do you want me to say them again, Mr. Jackson?
How so rude. You want me to say them again, Mr. Jackson? As if one of the other 3 people sitting at your defense firm didn't write it down. Want me to say it again for you, Mr. Jackson? I mean, she is keeping this train rolling down this track come hell or high water. And it's, in my 30 years of experience as a trial lawyer, this is very highly unusual. Karen Reed has waived her right to a speedy trial. Most of the evidence that the defense has been trying to obtain, basic discovery, was not turned over until December 1st of 2023. We went over that in the motion. So they've barely had not even 90 days to look at the basic items of discovery that the prosecution was dragging their feet on for over almost 3 years. Well, 2 years, because it's 22 to 24, almost 2 years.
So on March 22nd, all motions in limine must be filed. On March 28th, at 9 o'clock in the morning, we'll have a hearing on those motions in limine.
Okay, first I'd like to discuss with you what a motion in limine is, because there may be many of you who do not know what a motion in limine is. A motion in limine is an evidentiary motion that is held before trial, which is either to exclude or include certain evidence at the trial. For example, the defense may want to preclude any reference to the hearsay that was in the prosecution's opposition about anything that happened in Aruba, about anything that happened between Karen and Higgins. They may make that motion and say, for example, that evidence is more prejudicial than probative. It should not come in at trial, and it has no place here. It's not relevant. The court, outside the presence of the jury, obviously, and before the trial, will rule on these evidentiary motions and decide whether or not certain things can come in at trial. It can also be used to include evidence for the same reasons. Like, we want to make sure this evidence is going to be able to come in. And a lot of this is done prior to trial. It's done on papers, and then it's done in this courtroom. Anyway, it's done orally. They need to orally argue the motions in limine. So let me know that that makes sense to you. If you have any questions on that, just let me know. It's good to have the evidentiary issues about what's coming in and what's not coming in decided prior to trial. But then, however, if one of the sides opens the door to that evidence, it may come in anyway.
On April 12th, there'll be a final trial conference at 9 a.m. And on April 16th, the jury trial will begin. So it's a 5-week continuance of this jury trial. So I'll hear you.
So I'll hear you, but I don't really care what you have to say, but I'm going to be nice and let you speak. Because putting this trial over for 5 weeks, in my opinion, is no way enough time based on the document dump that they received from the feds about the investigation of the Karen Reed investigation 5 days ago.
I appreciate that, Your Honor. Thank you for hearing me on the issue of scheduling. I just want to bring to the court's attention a couple of things. I appreciate the court accommodating us in terms of the motion to dismiss today. I was prepared to argue the motion to continue on that issue, unprepared to argue substantively the motion to dismiss.
We're not.
I understand that, but for the following.
We're not. I don't know why she can't just let somebody finish a sentence. I don't know. Am I overreacting? I don't know why she can't let anybody finish a sentence.
Following reason. We received 3,074 pages, 1.3 gigabytes of data. We've only had a chance to go through a smattering of that data so far, right? Okay. So a couple of transcripts, we've reviewed and looked at or put our eyeballs on the files, but not the substantive data contained within those files. And I would dare say that the Commonwealth is in the exact same position. There has been an additional TUI request by the Commonwealth that the court is probably not aware of. That came in on Friday. Ms. McLaughlin asked the U.S. Attorney's Office, pursuant to TUI, which is exactly the same protocol that we utilize to get these almost 3,100 pages of data. And so we're expecting that to be heard at some point through the U.S. Attorney's system. In other words, they're gonna have to go to the magistrate, deal with the TUI system the same way that it took place here. And that takes not days, but weeks, I expect.
So there's another TUI request made by the prosecution last Friday. Perhaps they didn't like what they got and they're looking for some more stuff. And again, if that motion is granted or that TUI process, you saw how long it took for them to turn over this material. You know, the TUI process is jumping through hoops and it's a procedure that needs to be followed. And we thought that the TUI information was going to come a lot sooner than last Wednesday, February 21st. So now, based on the fact that the Commonwealth made an additional motion for more stuff from the feds on Friday, that could take another couple of weeks at least.
We also haven't finished the Bodie protocol, which is the state's protocol with the crime lab that you're well aware of. I say that to say, through 2 years of litigation with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative.
Bam. Bam. In 2 years, the Commonwealth has handed over 3,200 pages of evidence, and in one day, the feds gave us 3,100 pages. What say you?
All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory.
Exculpatory means it shows that Karen is not guilty. That is what exculpatory means. For those of you not familiar with legal lingo, exculpatory evidence is evidence that tends to prove innocence. And as you know, under the rules of the Constitution, and you know I'm a constitutionalist, every defendant is afforded the presumption of innocence. Except maybe in this case, it seems. I don't know. I'm going to take that back a little bit because we need to hear that again from AJ's mouth. Smooth as butter.
In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory. The schedule that the court has suggested, although I'm mindful of moving this along, I can't do it in violation of my client's due process rights. I can tell the court there is no possible way that we'll be ready for,
Meaning her due process right to a fair trial. Every defendant has the right to a fair trial.
just to grab my notes, there will be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss by March 6th. That's
So
just too big.
what I need you to do,
Hold on, Kathy Chapin says it's not all new. That's what the defense says, not the prosecution. Have you seen, Kathy, the document dump? Because if you have, then that's amazing. I submit to you the feds did a separate investigation than the Commonwealth, and so it's definitely different information. They're not going to regurgitate back to the defense all of the same discovery that was turned over by the Commonwealth because it's a different proceeding and it's a different investigation. I don't know. That's what I say.
in writing, why?
Sure, there'll be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss by March 6th. That's
So
just too big.
what I need you to do is put in writing why.
Sure.
You need to put it in writing. Why? Because I'm not just going to take your word for it orally. I'm going to put the burden on you to do another motion for which Karen Reed will be billed however many dollars an hour for you to prepare, instead of you just telling me why orally here today while you're in court that you flew to California to be here for, why you can't have it done by then. Now I'm going to put the burden on you to make a motion and bill by the hour. I can't even imagine, my friends, what the legal fees have been so far in this case. I can't even imagine. It's not good enough that he says there's no way that we can be ready by then, because all of us with our common sense are thinking that's insane to have this supplemented in the next 9 days, during which 2 of them are a weekend. But make another motion and tell me why you can't.
All
Sure.
right.
I can tell.
I am very mindful, though, where the U.S. Attorney says we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So put something in writing, get it to me by this time next week as to why you cannot be ready specifically. But I'd urge you to use that time getting ready.
Really? I'd urge you to use that time getting ready. I want you to do a motion to tell me why you can't be ready, but I'm probably not going to grant it. So I would urge you to spend your time getting ready. Because it's not enough that you just told me, and not only did you just tell me, but I'm sorry if I'm speaking too loud and blowing you out, that the deputy U.S. attorney also sent me a letter telling me that you were indeed turned over 3,000, actually 3,074 pages or 1.3 gigabytes of data from the federal investigation. That's not enough. I want you to not only tell me why you can't get ready, but in the meantime, still get ready. What? What? I mean, where's Judge Newman when you need him? Wasn't that the Murdoch judge?
All right?
May I have just a moment to confer with
Yes.
counsel?
You're doing good. You're doing a good job, Great Dane, Mom. You're doing your best. She says, with a job like with the judge like this, it's taken so much self-control to stay classy. Galen, Judge Bev acts like nobody's watching and it's all happening in a bubble.
Your Honor, thank you for accommodating that quick chat. I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention. I don't want to speak for him, he can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar, and he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So
There's
you
gonna be-
can put that in writing as well, Mr. Yannetti.
That's fine.
I just want to put a sort of a precursor to the court. We expect additional rules based on what we've got so far.
He's like, yeah, I will do that. Yeah, I will do that. Because we went over the motion to disqualify and for sanctions the other day. That's the one motion that we did have both sides on. And we were able to read that, and it's voluminous. And it's based on prosecutorial misconduct, based on Morrissey's video statement that he gave. And the entire opposition to that was, don't look over there, look over here, look over here. Turtle boy, Aiden Carney. Nothing to see here. They did not even address all of the failures to turn over the evidence. And we went over that at length. And if you haven't watched it, the title of that stream is called something like Motion to Disqualify and for Sanctions. And I think that was just 2 nights ago. I lose track of days, but I think that's what it was. So for them to now be dumped all of this federal information, which is information of the federal investigation into the investigation, which goes directly to the heart of the motion to disqualify and for sanctions. And for her to now say, well, put it in writing why you can't be ready to argue that motion. Well, because there's 3,000 more pages of new information that goes to the heart of that motion. It's a little unconscionable, strains credulity that they could be ready. And by the way, there's not even a date on the calendar for that yet.
Far. And I'm happy to describe a sampling of it if the court wishes. But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we just received. And all of this has to predate any reasonable effort that we have to prepare for trial. So my suggestion, and we'll put it all in writing as the court suggested, but I can tell the court that based on what I know, and I know that the court is operating a little bit in the blind because you don't know what we know, what we have. An April 16 jury trial date is probably not realistic, but I will put all of that, as the court has directed me to. We'll put all of that in writing, and we will suggest what we think is a reasonable trial schedule and briefing schedule based on what we've just received.
Okay, let's take a little short break here to go over the difference between a Rule 17 motion and a Rule 14 motion. A Rule 17 motion is to obtain third-party records or third-party discovery. And he says that they are going to be making based on what the feds have turned over, significant Rule 17 motions. And that is the process whereby a lawyer can ask the court for a summons for third-party records. Third-party records like they've already asked for them and they've been granted narrowly. Jen McCabe's cell phone records, Jen McCabe's Google searches, Brian Higgins's, or things they may not have asked for yet. Maybe they want Brian Higgins's, cell phone information, text message information, Brian Albert's cell phone information, Trooper Proctor's cell phone information, all kinds of records that come from third parties. And he says that based on all of the mountain of evidence that they've just received, they are going to be making significant Rule 17 motions. Rule 14 motions are regular discovery motions where they're asking the Commonwealth to turn over discovery that they have not turned over yet, things that they need to either test or look at, or other things that have not been provided. So based on his cursory review of the documents that they just received, as he says, a little over 2 business days ago, they're going to need to be making significant additional motions prior to trial. And she's now set the trial date for April 16th, which is 5 weeks from the original trial date of March 12th. And he says, no way, no how, ain't happening, because you're violating her civil rights of letting her have a fair trial if you do that.
Okay, so I need that by next Monday at the latest, okay?
Monday, 1 week.
Ms. McLaughlin.
A week from today, yes.
If I may, the Commonwealth has had the opportunity to go through all the discovery that's been provided.
If you didn't hear what she said, Your Honor, if I may, the Commonwealth has had the opportunity to go over all of the information that the feds have provided. I'm not sure who this attorney is. If anybody knows, has she been there the whole time? Because I don't recall seeing her at any other hearings. But, you guys, we've watched them together, but I'm not sure. Okay.
It is voluminous. It is, there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth.
Okay. Well, like I said, I don't think the feds are regurgitating back all the witness statements that both sides already have, because this was an entirely separate investigation of the investigation. So if she's saying that all of the witnesses who testified in front of the federal grand jury testified in the same way that they testified during Karen Reed's grand jury, which was in May of 2022, that could be a problem for anybody who continues to perhaps state mistruths under oath in a federal grand jury. But that seems to be what she's saying. And she was probably working all weekend reading all of this stuff. But again, we don't know what it says. We're not going to know what it says. And it's sealed. They're allowed to refer to it, but not attach it as any exhibits that are unimpounded, or talk about, I guess, the sum and substance of even what it says. So,
Thank you.
All right. All right. So put it in an affidavit. Find
Alan is standing up. He's buttoning his jacket. He's like, I have more. I'm not finished. Look at that cool bracelet he's got on his right hand right there. I wonder if he was at the Dave Matthews shows in Cancun this weekend, because I think I got one just like that.
next Monday, but these days, as of now, these are our dates. Okay.
I want to make sure I got the dates, all the dates that the court indicated. March 6th for the motion to dismiss.
To file any supplemental memos on the motion to dismiss and the motion for sanctions, disqualification of the district attorney's office.
The next date, March 22 for motions, all motions in limine.
Yes, for
March
filing all motions.
March 28 for hearing on all motions in limine. April 12, last readiness conference at
Yeah.
9 a.m.
Yes,
And April 16 for jury trial.
yes. Okay,
Your Honor, if I may, I may not have heard. The March 12th date, was that 9 a.m. or 2 p.m.?
March 12th, we can go at 9 o'clock and we can take all day. So, all right.
Your Honor, what are the dates for the Rule 17s that we anticipate filing, which we expect are going to be voluminous?
Why don't we do those on March 12th as well?
Yeah, why don't we do that on March 12th as well? Why don't we do that in 2 weeks from today? So you'll have to do all of these voluminous motions for third-party records and argue them within 2 weeks from today. But of course, the motions will have to be in at least 5 days prior to that, so that the Commonwealth has an opportunity to respond to it, and then you're going to argue it on March 12th. So why don't you put in writing why you can't be ready by that day, but in the meantime, be ready by that day. Where's Judge Hunter Carroll when you need him? You guys remember Judge Hunter Carroll from the Maya Kowalski case? He was a really fair judge. Thanks,
Okay, Your Honor,
Rochella.
we have the calendar that the court has suggested, and we'll file our papers by Monday.
Great. We'll see you on the 12th. Thank you.
Great. See you on the 12th. Great.
All right. You want a short recess?
All rise.
You can tell that Alan Jackson had so much more that he wanted to say, and he really restrained himself.
Goodbye.
And if you listen here, there's somebody who talks about being an intern. I caught this when I was watching it live.
All these.
I have a quick question. So I'm at Mondays and Fridays, and so I think that the jury trial is going to be on Tuesday. When I'm not scheduled for my internship, it's still specific right now. Okay, I was telling you.
She says, so I'm scheduled for my internship on Mondays and Fridays, and this trial's on a Tuesday, so can I come anyway or something like that, even though it's not a day that I would normally report for my internship? And I don't know who she's talking to, but it sounds like she's talking to the Commonwealth. Well, my friends, what say you? What say you? Get ready. Tell me why you can't be ready, but in the meantime, get ready. Edward Scott, there's some new information that defense will use in their motion. It's a very artful way of putting information that's so bad for our case, it shows extraordinary government misconduct. Yes. He said, in addition to the Rule 14 and Rule 17 motions that he wanted to make and supplementing the motion to dismiss and the motion to disqualify, that he was also going to be making a motion to dismiss based on extraordinary prosecutorial misconduct. You heard it. You heard it, right? Maureen, always the first one in with the super stickers. Thank you so much. Appreciating you, as usual. Hilsey, thanks for becoming a member. And Mystique has been a member for 4 months. Great people, awesome chat, amazing host. Thank you, my dear. PTSD Healer, thank you so much for your $10 super sticker. Oh, Glare, thanks for your 10. Thanks. Thank you for dumbing this down for me. Oh, it's my pleasure. Brian popping in here. Brian, you're going live tonight again, right? Brian was in court today and actually did some video this morning that I haven't had a chance to watch, but thank you for your 10 spot, Brian. LTL True Crime. Finally, some clarity among all the confusion. Free Karen Reed. Oh, thanks, PTSD Healer, for coming in again with the $10. Could they use AI to scan the documents for specifics? Also, why do you think the Commonwealth filed a 282? They could use AI to scan the documents. I don't know that they have that technology. I don't know how expensive that technology is. I would also submit to you that using AI in anything having to do with court proceedings is not a great idea, because there was a case in New York where a couple of attorneys could not afford to pay for Westlaw, which is the legal research program that is web-based, and you could do your legal research on there without going to the law library. They used AI to write their briefs, and AI came up with a whole bunch of cases that did not exist, and they were sanctioned in federal court, and it was a mess and truly embarrassing. So they probably could, but no. I suggest to you that you need a human to review those documents, just like anything else. It wouldn't be wise. Also, why do I think they filed a 282? Maybe they know of some other information that was not provided, because, as you know, several people came to Morrissey and told Morrissey that they were subpoenaed and that they did testify in front of the grand jury. Perhaps those portions of grand jury testimony was not turned over. The federal grand jury now we're talking about. Perhaps that's what they're looking for. Perhaps they know of other things that were done, or other investigations that were done, or interviews that were done, and they didn't have those in the 3,000 something pages. Maybe there's something specific that they're looking for. Hi, Amy in Boston. Thanks for your super chat. Melanie, couldn't a denial cause a mistrial or overturned verdict? Love you, Mama. A denial of what? Of an adjournment? Cause a mistrial? I don't know. I don't know what you're referring to. A denial of an adjournment and a denial of a request for more time. It could, I mean, it could cause a post-trial motion. I think she's just going to keep stringing everybody along and eventually give them more time. But in the meantime, it's hard to prepare when you don't know what you're preparing for, right? So yeah, put it in writing why you can't be ready, but in the meantime, be ready. It's like, okay, so where do I focus my time? Where do I focus my energy? Where do I focus my billable hours if I don't really know what I'm supposed to be preparing for? You know, they don't have a huge team. I don't know how many lawyers they have working behind the scenes and paralegals, but I submit to you that the district attorney's office has a lot more manpower than the defense firm, as usually is the case in most criminal cases. Thank you, Charlene, for the $10 super chat. Thank you, Attorney Melanie, for explaining this so I can understand it. Thank you. You're welcome. Tracy Ann, thank you also for your super chat. Thank you for making legal speak easier to digest. My pleasure. And Scott, thanks for your super chat. Good thing anti-Bev's forced continuances, although ridiculously short-sighted, give the feds more time. Tick, tick, boom. Free Karen Reed. Yeah, this is right. Filing useless motions by Monday. Again, Karen's legal fees are going to be astronomical. And based on all of this stuff, they are going to grow and grow and grow and grow. In the end, if this indictment is dismissed against her because of prosecutorial misconduct and because of false narratives and because of everything the defense is alleging, she may potentially have a huge lawsuit against the county for false prosecution and get her attorney's fees back, in addition to other things that are hard to quantify, like loss of your reputation, loss of your job, loss of a lot of things that you really can't put a dollar value on. So, you know, they better want what they wish for in a certain sense, the Commonwealth. You know, you're going to ask for all this other information. Maybe there's going to be other information in there that you're not going to want to see. Let's take a look at some court TV coverage from prior to the hearing, because this is interesting.
Let's talk about what we expect today in that courtroom up to the northeast, where a pretrial motion hearing for Karen Read is about to begin. And this is a live look outside the court. We're still an hour away from a motions hearing. It looks like they're getting ready for a Boston Bruins game or something there. No.
Did you hear his fake Boston accent? A Boston Bruins game or something there. Any of you see yourselves in the footage here? We have, is that, I don't know, is that Aiden right there? I'm not sure, but those of you who think that there's a fly on your screen, there's no fly on your screen. It's just my cursor. If you see yourselves, point yourself out.
This is a pretrial hearing. This case is unlike any other in terms of the mass, it's the interest of it in mass. They're going to have this hearing coming up at 2 o'clock Eastern time. We'll have it for you. Court TV Crime and Justice correspondent Matt Johnson has been covering this. He's with us here. Let's talk about what we expect today in that courtroom.
Well, outside, that was Aiden Kearney, who was known as Turtle Boy, revving up the supporters for Karen Read, who will be watching her walk into that courthouse in Dedham, Massachusetts in about an hour. Today's hearing is a motion to dismiss. It's also the last pre-trial hearing before the murder trial is set to start in less than 2 weeks, March 12th. Karen Read, as you know, is accused of running over her Boston police officer boyfriend, John O'Keefe, and leaving him to die in a snowstorm. The defense claiming that she's being framed.
All right, I'm going to stop this to give you guys your 15 seconds of fame here. If you see yourself in any of these pictures, I'm putting your name up here. I see there were some people who were in the courtroom and some people who were outside and see themselves. Carrie Ann says she has the red sweatshirt in the front.
In a big police cover-up. Well, today's motion to dismiss hearing could dive into the new details recently released about the case, including DNA evidence and a possible motive, according to prosecutors. In response to the defense's motion to dismiss, the state released details that...
Here's another great picture. Let's see. I have it on the big screen over here, but I don't see anybody that I recognize. If you see yourself in there, certainly point yourself out.
Led to the grand jury indictment, including John O'Keefe's DNA found on a broken taillight of Read's SUV. No dog DNA was found in the scratches on his arm and on his body.
Okay, that is not true. They were not tested. No tissue samples were taken. Vinny, if you're doing this tonight, call me. We went over this on your show. No tissue samples were taken from his arm. They're saying they were taken from his clothing, but who knows if it was, stop. I can't with the misinformation.
And John O'Keefe's hair was found on her vehicle.
No, it wasn't. No, it was not. What? Oh, Marie, I can see what you're saying. Marie said, I quit watching court TV today after this. I haven't watched this yet. So I'm watching it fresh with you. This is my fresh, unadulterated, unedited opinion. What?
And microscopic bits of broken taillight embedded in his clothing. Again, this all according to prosecutors. That's their evidence that they presented to the grand jury. State also says that the couple was in a toxic relationship. We could hear more about that. This has really divided the town there in Dedham, Massachusetts. This is an hour outside of the Boston area, Ted, as you know. And it'll be interesting to see just how large this grows. The number.
Wait, so is this from today or this is an old? This might be an old photo. I don't want to misspeak and say this was a photo from today, but they had some from today. Yeah, we didn't start the fire. Yes, HH, that's a Billy Joel song. Wish I could play it, but I can't because I'll get copyright stricken. I know. If you know, you know.
of supporters. These are pictures from earlier, some of the other hearings that we've covered. We've been there throughout this. If we have the live pictures, we can put that up. And that it is right there, live pictures to Court TV right now.
So that guy in the middle, that's Turtle Boy.
That is Aiden Kearney, who...
Isn't it Carney? Okay, so this is today, throwing Ted out to the wolves. Oh my goodness. All right, so there's Aiden. Brian, where are you? Brian, are you in this picture? Oh, there you are with the hat. I see you with the little newsboy cap, looking like Brad Pitt. Brad Pitt likes those newsboy caps too, you know. Somebody said she was in the red sweatshirt, so here's our red sweatshirt friend. Sorry, I can't recall who posted that. That's a nice photo. If anybody wants to, you know, screenshot it for yourselves, blow it up, frame it.
Is known as Turtle Boy. He is a YouTuber who is accused of witness intimidation, Ted.
Yeah.
Facing his own federal charges. He was in court earlier today.
Yeah, the paid protesters. Can everybody who was there today tell me how much your day rate is? How much did you guys get paid for this? Is it the non-union rate? Because I assume most of you are not SAG. So what is the non-union rate for background work to get hired for this? Like $100 a day? Did everybody get their money?
Case is just unbelievable, the amount of interest. When you have people picketing outside a courthouse before a case, and it's for the defendant, not, you know, we have lots of cases where people are coming for justice.
A defendant where the victim is a police officer, well-respected police officer in that community. It's not often that you see this for any defendant, but also that being an accused cop killer.
Absolutely. There it is. Free Karen Reed.
An accused cop killer where somebody is a cop killer. Somebody is. It may not be Karen Reed, but somebody's definitely a cop killer.
That sign says. And
you know, it's interesting because we'll see them cheer when she walks in. And in the beginning, in the earlier hearings, they were booing family members and the prosecution, and they've stopped doing that.
Oh, thankfully.
Because now, you know, when I talk to them, they say, you know, this is all about justice for John.
Yeah, it is. Isn't it all about justice for John? It should be. It's supposed to be. Not really sure that that clip was so much justice for John, but hang on, let's see what they had another clip. Let me pull that one for you. Talk amongst yourselves for a minute. I think they might have taken one down. Well, let's see. Here's a little 5-minute Court TV clip. Let's see how they report on this. I don't know. I think I kind of like my reporting better. What do you think? Yeah, Cheryl. Thanks, Cheryl. We only have 556 likes and 2,100 people in the chat. Please hit the like button and subscribe. It's free. It's free. It's a labor of love. Oh, thanks, Half Hammer. I don't look bad for 35. 39, actually. But, you know, 39 again. It's good to be 39 again.
May I have just a moment to confer with
Yes.
counsel?
Yes, Galen, I think that's why people come here for the chat. Because we're not toxic.
Matt, she looked pretty animated today talking with her attorney. She was smiling. How has she seemed to you in the times that you've been in the courtroom?
Very stoic. And it seems like she really appreciates all the supporters.
Your Honor, thank you for accommodating.
Here we go.
That quick chat. I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention. I don't want to speak for him. He can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar. And he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So
there's going to be
put that in writing as well, Mr. Yannetti.
That's fine.
I just want to put a sort of a precursor to the court. We expect additional rules based on what we've got so far. And I'm happy to describe a sampling of it if the court wishes. But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we just received. And all of this has to predate
Extraordinary governmental misconduct. I misspoke before and said extraordinary prosecutorial misconduct. Governmental misconduct, even better.
any reasonable effort that we have to prepare for trial. So my suggestion, and we'll put it all in writing as the court suggested, but I can tell the court that based on what I know, and I know that the court is operating a little bit in the blind because you don't know what we know, what we have. An April 16 jury trial date is probably not realistic, but I will put all of that, as the court has directed me to. We'll put all of that in writing, and we will suggest what we think is a reasonable trial schedule and briefing schedule based on what we've just received.
Okay, so I need that by next Monday at the latest, okay? Mr. Dolphin.
A week from today, yes.
Sure, if I may, the Commonwealth has had the opportunity to go through all the discovery that's been provided. It is voluminous. It is, there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we've received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth. Thank you.
All right. All right, so put it in an affidavit by next Monday, but these days, as of now, these are our dates. Okay.
I want to make sure I got the dates, all the dates that the court indicated. March 6th for the motion to dismiss.
To file any supplemental memos on the motion to dismiss and the motion for sanctions disqualification of the district attorney's office.
The next date, March 22 for motions, all motions in limine.
Yes, for filing all motions.
March 28 for hearing on all motions in limine. April 12, last readiness conference at 9 a.m.
Yes.
And April 16 for jury trial.
Yes.
Yeah, I thought this was a different clip. There was a clip that they had a talking head on that I can't seem to find right now, who actually made a lot of sense. But that was just a little recap of the hearing that we watched earlier. Kathy Murphy says TMZ would have had the 911 calls inside of a week. Yeah, I think you're right about that. I think you are 100% right about that. Vicinator, interesting. Some random lawyer for the CW made that statement. Yeah, that was interesting, right? I don't know. I thought that might be the intern, Mr. Cheesecake. I thought so too. Maybe it was. I'm not quite sure. Hey, Jay, now you have me singing Watch Out. You might get what you're after. Talking head song, isn't it? Very well done. Yeah, why do you think the 911 call hasn't been released? This is going to say exactly what we heard it say. There's a man passed out in the snow. Thanks, Jody Mitchell, for being a member for a month. If indictments are coming, do the feds have to wait for all of these hearings to make a move, or can they strike whenever they want to? They can strike whenever they want to. Whenever they want to, they can. And I think I submit to you that it would be in everyone's best interest for them to do it sooner rather than later, before more attorney's fees are racked up. So that's what I say. Ruby Chase says they're prepping her to step in when Lally goes to jail. I don't know about that. I don't know about that. I think he's just kind of a fall guy. I think he's just handed what he's handed, and he's got to go with it. That's his job. In my opinion, the 911 call is exculpatory to Karen. Just my opinion, says Joanne. She has spoken in court before, says Suzanne. She's under him figuratively, yeah. Alicia Smith, I believe that woman is the assistant DA. She's frequently there. Debbie Diggs this says, sorry, I think she's guilty. Everyone's entitled to their opinion here. I did cut down a portion of the show that I did with dog bite expert Garrett Wing, and I put it up earlier today. So if you think you've seen it before, you've seen it before. It's a shorter version. A lot of people don't have the attention span to sit through an hour and a half show, but I culled the most relevant portions, what I thought were the most relevant portions of the show that he did with me, discussing the injuries to John's right arm, discussing German Shepherds in general, discussing dog bites in general, and training of canine dogs. And I posted that earlier today. If you haven't seen it, go back and check it out. It's really, really interesting how anybody could think that those injuries to John's right arm or anything other than a dog attack is just beyond me. Like, I'm still in the twilight zone, because a lot of people are still writing, there's no way they could be dog bites. Okay. Did you watch the video? Did you listen to the expert who's seen hundreds and hundreds and hundreds of dog bites explain to you why they are? Thank you, Danielle. Great timing reposting that video today. It took 2 days for my appeal to be heard on that, because originally it was stricken as being unfriendly content. So I had to wait before I posted it. Care Bear says, I think J.O.'s phone pinged with J.M.'s phone because they are in contacts and each other's phones proves he was in the house. Yes, a lot of people think that. A lot of people think that. Annie says, I watched your cut down dog bite video after watching the whole long video. You did an awesome job on it. Thank you. Thank you very, very much. I appreciate you. Thanks, Cal. Let's debate respectfully. Please keep it civil and classy. Thank you. Let's deal with the phones pinging with other phones. Not a cell data expert, but Microdots has a great video on geofence data, on the geofence data in this case and what it will show. If you haven't seen it, go to Microdots YouTube channel and watch that video. She does an amazing job with graphics and everything, and it just makes it really easy to understand. Island Girl says Lally swore an oath and is not adhering to it. Coward. Barney says, or J.O.'s phone connected to the home's Wi-Fi. Barbara Murphy, off topic, but is that a fire dancer on your charm? Yes, I got this. I was at Dave Matthews in Mexico this weekend. And it is. No, I can't really see it. But earrings too. Look. Check it out. Made by a guy named Javier in Cancun who goes to all of those Cancun shows and makes jewelry for each show. So yes, it is. Thank you for noticing. I love it too. Marie says evidence being consistent with the Commonwealth theory doesn't mean it's not new. That is true. Kathleen says, I really thought charges were going to be dropped today. I think a lot of us did. I think a lot of us thought that. You are not alone. Kathleen, you are not alone. We thought that too. Let me see if I can, where's that other video that I saw on Court TV with that talking head? Hold on, I can't seem to find it. I thought it was on Twitter. Maybe they took it down. It's possible. Well, I can't waste too much time trying to find it. But in any event, any more questions, my friends, before we wrap for today? There's a lot of coverage on Karen Reed today. Go watch it all. Lisa says Bev probably won't drop the charges no matter what. Ruby Chase, I knew they wouldn't be dropped today, but I thought Jackson and Yannetti would get to squeeze in a little more interesting information. You could see that they tried to. They tried to. She kept shutting them down. She knew what they were trying to do. She knew that they wanted to say some stuff, and she shut it down. So that is my opinion, and I'm sticking to it. Juice Man says the state's taking this to trial. I don't know. We're going to see what happens before that. I don't know that it's going to get that far. I see the judge in this case, Judge Cannoni, pushing the train down this track with massive force. Doesn't seem to want to budge any on the dates. If you're just tuning in for the first time, the hearing on Karen Reed's case was held today. And during that 15-minute hearing, it was revealed that on February 21st, which was just last Wednesday night, both sides were given a document dump by the U.S. DOJ, the Department of Justice, the U.S. Attorney's Office. They were given 3,074 pages of documents. That is approximately 1.3 gigabytes of data that the defense has categorized as exculpatory to Karen Reed. They have not had a chance to look at it yet, or all of it yet. On the flip side, the ADA got up on Lally's side and said that she did have a chance to review it and that 90% of it is in line with the Commonwealth's theory and that they didn't think it was anything different than we've already seen in this case. We're never going to see that stuff, probably, so you be the judge on that. The judge has adjourned the trial to only April 16th, which is 5 weeks from the original trial date of March 12th. She is demanding that the defense file its supplement to its motion to dismiss the indictments, which we went over, by March 6th. March 11th, the Commonwealth must respond by that date, despite Alan Jackson's protest that it was impossible, that they have so much evidence to review that they're not going to be able to respond to it in time. And she said, well, you can make a motion and put it in writing why you can't be ready in time, but in the meantime, you should be ready in time, basically, is what she said. On March 12th, there's going to be hearing all day on the numerous Rule 17 motions that the defense said that they are going to file based on all of this new information. And just to recap, Rule 17 motions are where lawyers ask the court to give them summonses to get third-party records, people who are not involved in the case, such as any witnesses who are in the house, their phone records, or anything like that. Those are going to be held all day, she said, if we need to be here on March 12th, which was the original trial date. By March 22nd, they are required to file all motions in limine. And as I explained to you earlier, motions in limine are based on what evidence they think should be excluded or included from the trial, made pre-trial so that the court can rule on them regarding certain pieces of evidence or theories of evidence. April 12th at 9 a.m. is going to be the final trial conference. And April 16th, the case is still scheduled to go to trial. Commonwealth says that they are going to be making, or they did make actually on Friday, additional TUI requests of the federal government. So it'll be interesting to see what they're asking for, and it'll be interesting to see what gets turned over. So in the meantime, my friends, thank you for tuning in to recap this with me. I hope it was helpful. And I hope that you will hit the like button on your way out, subscribe, it's free. Thanks for hanging out with me today. Thanks to my moderators for keeping the chat classy. And thank you to my members, my viewers, my replay viewers. And remember, be cool, be kind, be classy. It's not hard. It is really so not hard. Peace, everyone. We'll see you soon.